And what can happen, and you guys would have seen this quite often, I would think, is that a lot of properties get sold on the weekend. Now, most lawyers and conveyancers aren't open to check contracts.
No, they're not. They're not normally open on a weekend. I'm very aware of that. Normally they're at the golf course if you want to catch them.
My word, we are. Why wouldn't we be?
Welcome to Smart Selling Steps with Cardinia Property, where you'll get the insider insights on the best way to get your property sold in the current real estate market.
Welcome to the Cardinia Property Smart Selling Steps podcast. We are lucky enough to have Stuart Day, lawyer extraordinaire from the local company Fennally Legal with us today. Thank you for being with us,
Oh, thank you,
Stuart.
Sarah and Jackson, for having me. It's terrific to be
Would
here.
it be okay if we shorten your name to Stu throughout?
Go for it.
Great, awesome. Thanks for being with us.
So, Stuart, it's obviously a big part of our professions are closely linked.
Absolutely.
Obviously, every transaction that we do has to involve a legal aspect or conveyancing, or so that's kind of the first question. So, what is the difference between a lawyer and a conveyancer when it comes to someone buying or selling a house?
So, well, the main difference is really that lawyers have greater responsibility. So ultimately, conveyancers, and there are many of them out there and they're terrific, a lot of them, they can just do the conveyancing transaction. Lawyers also do conveyancing, but in Victoria...
So conveyancing means the change of the title of a property from one person's name to another. Is
Correct.
That right?
That's exactly right, Jackson. So for a real property, a house, anything that's not personal, so a house, block of land, unit, real property, it's called. For that to be sold, there has to be a contract of sale. There's a legal requirement, the Sale of Land Act, and under that, for a contract to be enforceable, it has to be in writing, signed by both the vendor and the purchaser, and it has to contain, there's a number of legal requirements in that contractual document. Starts off with what we call the Section 32 vendor statement. That document tells any potential purchaser all the details of the property. So it has a copy of the title in it, copy of the plan, effectively shows the vendor's right to sell the property. It contains things like council rates, water rates, if there's been building permits. There's any number of things that is legally required to be in there, and if it isn't in there, there is a chance that the contract may not be enforceable and the purchaser may be able to
Pull out.
Exactly.
So basically what you're saying is the Section 32, some people say Section 32, some people say vendor statement, but it's the same thing, right?
Same thing, exactly.
The Section 32 is the information about the actual property.
Correct.
And then the contract of sale is the information about the sale of the property.
Exactly
so the
right.
price and the property settlement times,
Absolutely.
who the buyers and sellers are, etc.
That's exactly right, Sarah. So the Section 32, or the vendor statement, is the same no matter who buys it.
Yeah.
So that is information purely about the property. The contractual part is really the deal done between the vendor and the purchaser, and contains obviously the purchase price, the deposit, the settlement, as Jackson said, who the real estate agent is, the legal representatives.
And other conditions.
Exactly. Any other conditions have been negotiated between the parties.
Yep.
So you mentioned about that's what we or real estate agents or the vendors, the sellers need to sell their property. Is there anything that you need from them? What do you need? Like if someone says, I'm selling my house, or I've got my house going on the market, what do you need them to give you to help you pull that paperwork together?
So the first thing we need to do is obviously get a lot of information from them. So as silly as it sounds, the address of the property,
Yeah.
their details.
Don't laugh.
Have you ever done
I've been involved with 2 transactions where the incorrect address was on the Section 32 statement and the incorrect block of land was sold.
Oh, wow.
Which and it wasn't discovered till after settlement. So
Yeah.
that's happened twice.
Yeah, it can happen.
in 30 years? Not a regular thing
No,
to our listeners.
No, well, ultimately what you are buying as purchaser is what the title
Document says.
what the document says, the title, so that the address written in the contract or on the 32 is really I won't say not relevant, but in any dispute, it is the actual title to the property specifically.
Yes.
And things happen where sometimes council will in fact change an address, but the title itself doesn't change. You know, sometimes if you're on a corner.
Or if a property has been subdivided, like the back one becomes A or B or whatever it is.
Exactly right.
So
Sarah, that's
coming
correct.
back to what do people need to give you so you can prepare those documents?
So to start off with, we get the address. Ordinarily, we want to get a copy of the council rate and the water rate because that's
the latest
information.
version,
The
obviously.
latest version.
Yep.
That's not always available, but that's, you know, we can search that, but that's good information that the purchasers want, and every real estate agent wants that in there because you want to give as much info to the purchaser as
Correct.
possible.
Yes.
We need to know details of any building works that have been undertaken in the last 7 years, and that's not just if there was a building permit. And this is where a lot of vendors can come unstuck. The old owner-builder works cause all sorts of problems.
It is because some people might have done work themselves and they don't think that that work needs to be reflected in the documentation. But where do those triggers kick in from that point of view?
So there is some debate about it, but clearly anything that needed a building permit,
Yes.
whether it had one or not, absolutely needs to be disclosed.
So example would be decks.
Yes, decks cause all sorts of problems. A lot
Yeah.
of people don't think they need decks, and the regulations can be difficult to negotiate. Certainly from my point of view, we're always on the conservative side by saying, well, there's no point risking a sale by not getting a defects report, just get one.
Can you get them in retrospect? Can you get a building or
No, you
not?
can't. You don't get a building permit in retrospect. You can get consent from council that what you have built can remain,
Yes.
provided it's obviously up to code.
Okay.
And then what about works inside? So, for example, if I have fully renovated a bathroom or a kitchen and it's the same footprint as the original property, but I might have spent, I don't know, does it come down to how much money I've spent on it or what is it?
No, it doesn't. Some people believe it does. So where there are any works like that undertaken, we always recommend you get an owner-builder defects report to put in there. It may be on the conservative side, but we do not want to risk the possibility of a purchaser being able to pull out of the contract
Falling
having
over.
a defective
Yes.
So
Section
what
32
does an
statement.
owner builder's defect report, what information does that give, and how does that then protect the owner?
Okay, so it's actually under the Building Act says that where any works have been undertaken at a property, not by a registered builder, then a vendor must provide an owner-builder defects report. And all the defects report does, those works could be illegal, could be anything. It's a matter of disclosure to a purchaser.
Okay.
So do you get it from, how do you get it? Like, does a registered builder just come in and do it, or is there
Registered
people that come in?
Yes, so there are people that do the owner-builder defects reports. Quite often they will also do building inspection reports if people want those. All it does though, it just points out defects. It doesn't guarantee the quality of the work. It doesn't say the works are legal. It doesn't say if they're built brilliantly or
So
not.
it's just disclosure, really, isn't it?
Pure
So
disclosure.
with say, for example, you've had a bathroom done and you've had a tiler and a plumber come in and an electrician to move the power points, whatever. Do you still need that defect report if you've had those trades in there?
That becomes a bit of a question of where the line is actually drawn. So once again, I always recommend get the defects report. It might cost you $400 or $500, but if you're selling an $800,000 or $1 million property, why take the risk?
Yeah.
Those works have been done by professionals, and quite often they will just simply provide an electrician would provide a compliance
report.
certificate.
I'm just thinking out loud. Sorry, I've interrupted here.
Yep.
If you got your so a lot of people get a building inspection, pest inspection done after they bought the property. It's a condition of the sale. If you had that done before you put the property on the market, would that be a similar thing to a defects report?
So they're two different things. One is the defects report is a legal requirement
Okay.
to ensure that the contract is enforceable.
Yes.
A building inspection report, for example, and this is another thing I'd recommend, though a lot don't do it. I'd say to most purchasers, if you're going to get a building and or pest inspection report, get it done before you sign the contract. You guys would have seen plenty of contracts where it is subject to the purchaser getting that report. For a purchaser to be able to withdraw from the contract, that report ordinarily has to show a major structural defect.
Yes.
Now, the house might have multiple defects that aren't major or structural, and that will not give a purchaser the right to withdraw from the contract.
No, and I've seen it being used in every way, as potential buyers use it as a strategy to nibble more of a discount. I think that, you have to be very clear around, and that's what I've seen too, is the formulation of the standard clause around the building and pest inspections, because there's a whole different way of writing those clauses that benefit either one party or another.
Absolutely, 100%. Sometimes you will see purchasers try and put a condition in that says it's conditional upon getting a report, a builder's report, and if it is not to the satisfaction of the purchaser can pull out.
Yeah, so a lot of, I don't like to generalise, but sometimes I've seen buyer's agents have them a bit more general like that.
Absolutely.
Buyer's advocates.
That's their job. I don't blame them. If I'm acting for a purchaser, I'd absolutely want that condition in there. If I'm acting for a vendor, there is no way I'm allowing it in there.
It's as you said, get it done before you buy it, and then factor it into the negotiation.
So from a
100%
seller's
check.
point of view, it would be good to check with either the conveyancer or the lawyer around the exact wording of that clause, and make sure, and obviously it's the lawyer or the conveyancer's job to protect their client. So you would hope that they would have it pretty watertight.
Oh, absolutely. And what can happen, and you guys would have seen this quite often, I would think, is that a lot of properties get sold on the weekend. Now, most lawyers and conveyancers aren't open to check contracts.
No, they're not. They're not normally open on a weekend. I'm very aware of that. Normally they're at the golf course if you want to catch them.
My word, we are. Why wouldn't we be? And so what can happen sometimes is that a vendor have had the contract prepared by their lawyer or their conveyancer, and it sells over the weekend, and then we get the contract on a Monday or a Tuesday morning and find out there's a condition in there that we haven't seen, because quite clearly everyone wanted to get the contract signed, and it is in fact a condition that we would not have allowed our vendor to include, like the one we just mentioned, where it is a building report to the purchaser's satisfaction, which can mean anything. They could be unsatisfied. They might say there's a broken light, and they go, "Well, I'm not buying the place now."
Yeah, and that's where each individual, either buyer or seller, has to rely on the professionals that are advising them, but also understanding the biases that are attached to each professional too. And when from your point of view, you're working on behalf of your client, whoever that is, the buyer or the seller, that I think at some stages though there is a real conflict around that, because you can, as a legal representative, you can have a real position on certain issues that are very, might be very, like, for example, some solicitors have a lengthy list of extra special conditions that they add into each contract, which if they were faced with that brought to them on the other side, they would no way agree to those conditions. So, and I don't know how you work with that, so I might be starting some trouble
Based
here.
on the smiling in the background, I think we're safe with Stu.
But from acting on behalf of the client, it's important, I think, for each party to get to the point that the client's aim a lot of the time is to actually complete the transaction, not to have a fight.
Oh, absolutely, I agree. We don't put a lot of conditions, standard special conditions, as silly as that sounds, in our contract. I know a lot of people do,
is
and
there
I
like
understand
a
why.
standard contract of sale, or is it?
Unfortunately not, Sarah. So until about 5 or 6 years ago, there were, as mandated by the government and Consumer Affairs, a list of general conditions that had to be in every single contract in Victoria.
Yes.
And the way you would vary those general conditions is via a special condition.
Uh-huh.
Unfortunately, they let that lapse, so that now anyone can write their own general conditions
Oh, really?
that are different to other people's general conditions. So What that tends to lead to is if you get a contract that is has been written by a lawyer or conveyancer where they've put effectively their own general conditions, but they look very much like what 90% of us use, you've got to go through those general conditions with a fine-tooth comb to find something that's different. It is one of the most stupid things I've ever seen. The government should simply go back to saying these are the standard prescribed 35 general conditions. If you want to vary them, it's done by special conditions. So a lawyer or conveyancer doesn't have to read the same general conditions, which might be varied by one or two words.
But it's dramatic in the meaning,
Absolutely.
So, like, key takeaway is to make sure that you've got, you trust the team that are looking after you, and you surround yourself with good professional people in transacting a home, because it's normally one of the massive
it's huge.
purchases that most people make.
It is, absolutely.
In relation to, so you must see lots of people selling for different reasons.
Yes.
So some of the ones off the top of my head are like if someone has passed away, or maybe a family situation is breaking up. Can you chat with us around, just some general advice? I know every situation is different, but if
Absolutely.
Like we were both talking to someone yesterday who deals in when people pass away, a celebrant. And she was saying that people just don't know what the process is and what they have to do.
No.
So
we get called, the day after a major marriage argument saying, right, I want to put the house on the market, we're separating, that's it. And I mean, there's obviously a lot of steps that have to happen before you end up at that point.
Oh, absolutely. So clearly one of the things you need is agreement on selling.
Yes.
So if you were, like if in a family split up
situation. In a family split up, clearly the day after is probably not the day to be engaging with your real estate agent, but if, each to their own.
If someone rang you though and asked that question, what would your advice be, straight up?
Well, once again, it'd be depending on what the circumstances are. One I find with family law is more the other way around, where one party is effectively dragging their feet.
Yes.
The relationship is over. It's obvious that neither party can remain in the property. It has to be sold, yet one party seems to be dragging their feet forever. I don't know why.
There would be a myriad of emotional reasons around that, absolutely. I imagine. And normally in a breakup situation, this is me putting my psychologist hat on here, there's, one party is a little bit more forward in their accepting of the situation than the other, which then may create that sort of imbalance in...
it can, and it would, I'll ask you guys, you'd obviously see some tension there sometimes.
And we are often, the old rule is that generally it's the person who's remaining in the house is dragging their feet on the whole process. But so it can be a challenge where we're getting... one side's wanting it to happen yesterday, and then it's the opposite for the other. So I think, and that's where it's really, I think we've had a couple of other comments that people have been in on the podcast on previous episodes where the main takeaway seems to be common in that getting to expert advice early is a key point, and I imagine that's the same thing with a separation.
Oh, absolutely. I think Sarah's right. If the property is to be sold, it doesn't mean someone's emotionally ready to take that on yet. So as much as I put my lawyer's hat on and say just get the thing on the market and sold, obviously you need to be in the right headspace to do it. It's probably no good for you guys dealing with a vendor that really doesn't want to sell.
And we're probably lucky in our when we get involved in these situations of a separation, that generally speaking at that time, still both parties, if the decision's been made to sell, they're both on the same side in that they want to maximise the price for the property. Whereas I imagine you would be in a totally different space where you're working on behalf of one of the parties, so there's a whole process that gets to that agreement of how the pie is going to be split up.
Oh, sorry, we both got something to say right at the same time. What would be the order? Like if a family situation breaks up, is it generally like you organise what's happening with the kids first, if there's kids involved, and then the finances, and then like
It can be different, but clearly when there's kids involved, they have to be the priority. So looking after the kids comes first. After that, some people seem to think that they need to finalise the percentage split up before they'll put the property on the market, which is just not true. If the property needs to be sold, it can be put on the market, sold, even if you're having a barney still later on about how much each party gets. You can continue to have that fight after settlement if it takes
and
that
the
long.
money can so we've had one recently where similar situation, and the money the property's been sold and settled, and then the lawyers are holding the funds from the sale in their trust account until the split up is figured out between the parties.
And my recommendation to clients is, in that situation, you don't need to leave all the money in a lawyer's trust account. It's not as if it'd be very rare that one party was getting every dollar and the other one was getting zero. So even if you haven't agreed on the split, it might be,
you get $20,000 each to live on for the next couple of months while we sort it out.
You need to go and pay a bond because you're renting somewhere. You need removalists.
Yes.
I guess the key things to change once that decision's made and it's agreed that to view the house as a pile of money as opposed to a house, which is, and that's a way of disconnecting the emotion to it. But the pile of money is easy to be broken up. When it is in the form of money, it's harder in a house because it can take a lot of time to liquidate a property. Like the average days on market is 7 weeks at the moment, and then plus a settlement time. So there's another couple of months. So you're looking at a 4-month time frame before anyone can get access to the funds if they remain as a house.
Absolutely, and time becomes an issue too. Not just that, because it does take a long time, or it can quite often. But dealing with one at the moment, I don't know when this pod will go out, but we're sort of mid-November at the moment, and clients are split up, and once again, one party is refusing to put the property on the market until they've reached a final agreement. We're saying, if you don't get it on the market soon, it's probably going to be end of January, which means by the time it's sold, you mightn't have your money till... Well, you mightn't be sold till much. You mightn't have your money till June next year.
Yes.
Whereas get it on now, you might find someone keen to buy it pre-Christmas, and you've got your money in March, all right?
Not only just from a logical financial point of view is it a benefit to do that, but mentally for people, and you would see this, I'm sure, and you know the cost emotionally of going through that process, it is horrible. And my advice to people whenever dealing with this, not from a real estate point of view, is that it should become a race to the end, to the finish line, because once it's wrapped up, there's a whole lot of emotional freedom that's given by putting the whole process behind you. It doesn't matter how amicable things are, the quicker you can move forward mentally, and once things are done, it's just a better, it's worth more than money to have that sorted out, and you would see that, I'm sure.
Oh, we do. We see it all the time. In fact, quite often in family law or any other negotiation, which is really what family law is, I liken it to selling real estate. And people say, what do you mean? So, well, I think it would be very rare that the minimum price a vendor would accept for a property happens to be the exact maximum price a purchaser would accept down to the dollar.
Yes.
And so when you say that, and it mightn't be much, but the vendor may have accepted a little bit less, the purchaser may have paid a little bit more, and that's exactly the same in family law. Look, you can hang around, you might get another $5,000 or $10,000.
Yeah, but
the ex might have accepted 5 or 10 less.
In order just to know what you're doing and have that finality and able to move on. Because I think one of the big things in life is just not knowing, isn't it? And it's one of the fears that not everyone, but a lot of people have in all different type of situations, is that when you don't know what's happening next or you don't know the time frame, it really messes with your mind. So just before we wrap up, Stu, we mentioned earlier around the when someone passes away. So when I'm speaking to people who where they're in that situation, which is they're obviously most of the time they're emotional as well, for different reasons. A question or a blocker that they will have already before they've spoken to us is, well, we can't sell the house yet because probate hasn't happened.
Yep.
Some people don't even know what probate is. So can you tell us what probate exactly means and how that sort of works in relation to when you can sell your house?
Absolutely. So probate is, in its simplest form, proving to the Supreme Court of Victoria someone's passed away, there was a valid will, and you were the executor named in that will. So when someone passes away and they own a house, from the moment they pass away, no one's got the right to sell that. No one's got the legal right to sell that property. There's no one alive that can sign on their behalf. People get confused. They think, oh, I was the power of attorney, I can sign documents. Well, you can't, because that stops immediately as someone passes away. So in order to settle, not to sell, probate must be granted. You can, in fact, sell a property prior to probate being granted. The contract of sale needs to be conditional upon probate being granted.
Okay, so what that means is that if someone was to pass away, their family could put their property on the market whenever they want, really, and then it would sell and the agreement between the sellers and the buyers would happen. But then if probate hadn't lapsed yet, it would just be
Hadn't been granted yet.
Yes,
Yeah.
just be conditional upon that happening.
That's right.
So is there an average time? Is that a silly question? Is that
It's
like
not a silly
how long
question.
How long is a piece of string?
No, it can take some time. So that it's a whole process. You've got to wait on the death certificate, and that can take quite some time. We need to advertise probate. That takes 15 days. Get the application in. That could take 3 or 4 weeks. There could be requisitions. It can take quite some time.
Like 3 months, 4 months?
It can easily, yeah.
And that's on a smooth sailing.
Yeah, exactly right.
If there's anyone contesting the will and things, and that, correct me if I'm wrong, that's the whole reason behind having probate. If there is a party who may have a claim on the will that they...
So in that case, settlement would still proceed.
Okay.
The parties would then, a bit like family law, potentially have an argument about divvying up the proceeds of the sale
Yeah, okay.
afterwards. But I mean, the other thing is, with what I would say to people in that situation is, A, get some legal advice, but B, even if you haven't been officially granted probate yet, speak to your family, the other family members, and my advice to them is speak to a real estate agent sooner rather than later. It's potentially more important at that stage to speak to a real estate agent than your lawyer, because quite often we see it all the time. You know, mum's been living in the house for 35 years. Mum passes away. The kids live in Melbourne. They come down. They don't know what to... And sometimes they will start saying, I will do this to the property and that. And my advice is always, no, don't. Speak to your real estate agent first. They will tell you what needs to be done.
Yeah, and then actually we can actually maybe assist them in doing that as well.
Absolutely.
Like we often will have a team of, you know, the gardener or the whatever, without spending a whole lot of money as well.
That's right. And the concern I have for my clients is they're going to go off and do all, you know, potentially spend money and do things that isn't even going to increase the value of the property or increase its saleability.
And coming back to the efficiency aspect of it too, oftentimes people get advised to do things that potentially may not come back in the price, but someone has to pay for those things to happen. So, how that all happens.
So probably when you're saying talk to a real estate agent, so making sure that you're talking to a real estate agent who actually has the best interests of the estate, as opposed to spending up big bucks and getting people to invest and therefore potentially commit to. Yeah, there's a whole lot of other
because the executor
to look out for there.
So the executor of the estate has a legal responsibility to maximise the value of the estate for the beneficiaries, and clearly one of those things is getting the highest possible sale price.
And also, like that's one aspect, but the other aspect is reducing costs.
Absolutely.
Stu, there's so much we could talk about. We
could
could go on forever. We're going to do another episode with you, but thank you so much. So this is really awesome information for people who are thinking about it in that stage before they're selling their property. So big takeaways, similar to, as Jackson said, some of the other people who we've had on. Speak to your legal team as early as you can.
Yep.
and then you can be armed with the information, I suppose, to make decisions.
Absolutely.
Yep.
Absolutely. Speak to your agent as early as possible. Speak to your lawyer or conveyancer as early as possible, because quite often things will take time from your guys' perspective to get the property up to speed, and also from our perspective, give us enough time to get a defects report required or get copies of documents, planning, permits,
Yes, yeah.
anything. It can take some time.
Well, the other thing, when things go wrong with real estate transactions, they can go wrong big time, and you guys
Absolutely.
can really prevent that from happening. Prevention's better than cure, and having the right team behind you when you're going through this it just makes what can be a horribly stressful thing a whole lot less stressful, where you've got good people behind you advising you. And,
Absolutely.
Thanks very much for coming in, Stuart. It's
Thanks,
great.
Jackson.
Thanks, Stuart.
Sarah.
Where can people find you if they would like to tap into your knowledge?
Oh, terrific. So we're at Fennally Legal. We're at Shop 1, 130 High Street in Belmont, opposite the KFC. Very easy to find.
Oh, lots of the men in the listening will know exactly where that
Definitely
is.
know where that is.
Just don't bring the KFC into the office. Thank you very much.
Right.
Just leave it outside.
That must be a challenging workplace, dealing with that beautiful smell wafting in the doorway
It's,
each day.
it can be interesting depending on which way the breeze is blowing, that's for sure.
Thank you so much, Stuart. We really appreciate your
Thanks,
time.
Sarah. Thanks, Jackson.
Thanks.